He's switching me around. Why don't you stop switching me the fuck around, bro?
How about you stop talking and listen?
You used the F-bomb with me.
No, I didn't.
Before we jump into this hearing, buckle up, because this case spirals out of control faster than almost any bond hearing you'll see. What starts as a defendant trying to explain why he missed court dates quickly turns into a courtroom showdown involving missed notices, accusations of disrespect, arguments over criminal history, claims of hearing problems, and one absolutely massive jump in bond amount. The tension here isn't just about the charges. It's about behavior, credibility, and how a judge evaluates risk in real time. As this unfolds, pay close attention to how both sides communicate. The defendant insists he never received notice and repeatedly says he's struggling to hear what's being said. The judge, meanwhile, is trying to determine whether this is a genuine misunderstanding or a pattern of avoiding responsibility. And then comes the moment that changes everything. A series of interruptions, escalating frustration, and comments that dramatically affect the judge's perception of the defendant. One of the biggest questions in this entire hearing is whether the defendant's actions are being misunderstood or whether he's unintentionally making his situation much worse. Was this simply a communication breakdown that snowballed out of control? Or did his courtroom conduct convince the judge that stricter conditions were necessary? Stay with us, because what happens later leaves the defendant stunned when a bond amount that started dramatically lower suddenly explodes to a figure he never expected. And by the end, you'll have to decide for yourself. Was this a fair response from the court, or did emotions take over the hearing? Let's get into it.
Sir, Sergeant, your name or corporal? I can't tell.
Sergeant Mitchell.
James Schlock 30720.
These guys don't get it, do they? Why didn't you show up? Why didn't he show up?
And my mail goes to I'm in an apartment complex, and I don't get no. Sometimes I don't get no mail at all.
You remember getting stopped, right?
I'm sorry, what? I can't hear. I'm half deaf. I'm sorry. I'm half deaf.
All right, let me put it to you this way. You got stopped. I don't want you to acknowledge that you did, but at some point it's going to be pretty clear to me that you did get stopped. If you had mail issues, you should have called the courthouse. You should have called the police department. Now you got yourself in a real predicament. What, is there a problem with something I just said? I don't want you to cop an attitude with me. If you do, we're going to have a bigger problem.
No, I'm half deaf. I can barely hear you. I'm half deaf. I can't hear you. That's the problem.
Okay. All right. Can you hear me any better now?
Yeah, that's all the problem was. I couldn't hear you before. Now what's going on?
Does he stand mute and waive formal reading?
Yes, Your Honor.
I'm entering a not guilty plea. I got an operating with the presence of drugs, and I got a resist, hinder, and obstruct an officer charge. So your lawyer is telling me you stand mute and waive formal reading. Has he been printed on this, Sergeant?
Yes. Yes, he has.
I want to know why he hasn't shown up.
I apologize.
Why did you not show up?
I didn't get notice.
Well, you knew you got stopped. You should have called the court. We sent it to... Is that your address?
That's my address, but sometimes things get dropped. Sometimes things get dropped. You know what I mean?
We sent 2 letters there. If they came back, we would have put them in the file.
Oh,
you were supposed to be here on April 30, and then you were supposed to be here on May the 14th, and you didn't show up either time, and I don't have any return envelope.
At this point, the judge's focus isn't really on guilt or innocence regarding the underlying charges. Instead, the court is looking at something equally important during a bond hearing: reliability. From the judge's perspective, there were multiple missed court appearances and no record showing the notices were returned as undeliverable. That's significant because judges often evaluate whether someone is likely to return to court if released. Notice how the defendant keeps emphasizing mail issues while the court keeps returning to the same question. If you knew there was a stop or pending case, why wasn't there a follow-up call? This is where many defendants run into trouble. Even when there may be a legitimate explanation, the court often expects proactive efforts to stay informed. What do you think? If someone genuinely never receives court notices, should they still bear responsibility for tracking down their court dates? Or should the system provide stronger safeguards before assuming someone intentionally failed to appear? Let us know in the comments.
Or any envelope stamped that was
Well, I went to
sent
the
back to
hospital
the
for 15
courthouse, or it would be in the file. Where does he work?
He's on disability, but he has no prior cases. He did tell me about his mail issues. And,
He's got prior cases. I mean, he's got a heck of a history here. Home invasion, 98. Impaired,
You can't hold that
99.
against me. You can't hold that against me. You can't hold none of that against me because that was over 12 years ago. You can't hold none of that against me. 10 years or older, they don't hold it against you.
sure, it's your history. I will tell the court that it is pretty old and, you make the right conclusions based on that.
Oh,
I'm
we're talking
just- You can almost
I'm getting mixed signals. I'm getting mixed signals. Yeah, you're gonna talk about my history. Just 10 years or older.
Really? Thank you.
I could just go to trial with it and then show you that they kept me in the police station for 2 days before they took me to the hospital to even prove that I had drugs in my
Talk
system.
about the substance,
And
especially
they kept me for 15 days in
open
the hospital.
court.
And then,
You'll have an
now you ain't
attorney
doing
next
this.
time who
Just let
will
me go,
be able
I'll come to
discuss
court and I'll
those-
take care of it, I promise.
Sir,
I just
you'll
didn't
have
get
an
notice.
attorney next time who will discuss those issues with you. Today, we're just concentrating on bond.
I was reading your history as I was reading it
Yeah,
to
well,
myself.
you can't read my history because it's over 10 years
Yeah.
old.
Don't interrupt.
Are you
the
dealing with me
judge.
or dealing with them? He's switching me around. Why don't you stop switching me to fuck around, bro?
How about you stop talking and listen?
This is the turning point of the hearing. Watch how quickly the conversation shifts from discussing missed appearances to discussing risk assessment. The moment the judge interprets the defendant's behavior as defiant or non-compliant, the entire tone of the proceeding changes. A lot of viewers focus on the dollar amount, but judges don't simply pick numbers out of thin air. They consider factors such as prior failures to appear, criminal history, community ties, public safety concerns, and whether the defendant appears willing to follow court orders. The key phrase here is flight risk. Once a judge becomes concerned that a defendant may not return to court, bond conditions can become dramatically stricter. The real question is whether the defendant's frustration was understandable given the circumstances, or whether those reactions ultimately convinced the judge that stronger restrictions were necessary. Either way, this is a textbook example of how courtroom demeanor can influence outcomes in ways many people never expect.
I'm going
I
to
can't
set
if
you
I'm deaf.
down now. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. If you're going to be so defiant, that tells me you're a flight risk. 40,000, 10%. No alcohol, no marijuana, no illegal controlled substances. None.
My bond is 40,000.
10%. It could be
Can't
40,000
be because
if you use
it
the
can't be
F-bomb
because
again.
I have 2 misdemeanor charges, bud.
Sit back.
We're going to trial then, bro.
Sit back.
It came in from $750 to 40,000 over nothing. I'm fucking this whole state up then, man.
You got
We're going
about
all the way to
15
Supreme Court. We're going to court on this.
You got about
You
15
can't sit there and then take me from a $250 bond to 40,000 for nothing.
You just used the F-bomb. You're disrespectful. I think you're a
No,
flight
I'm not.
risk. You got 15
I'm
criminal
not. How am I a
convictions
flight
on
risk?
you. Listen,
I live right here. I didn't have a car.
Stop interrupting.
I can't
40,000.
hear for one.
well, you seem to be able to hear when you started to defend yourself. 40,000, 10%. You cannot leave the state, cannot violate a law.
So you keep me
You
in
must
jail the whole
appear-
time?
Listen, if you give me one more bit of guff, I'm setting this case for next October, and I'm setting a bond of 100,000 cash. You want to keep going on, tough guy? You want
I'm
to
not
keep
being
going
tough. I
on,
can't-
tough guy? Feel free.
I want a
Yeah.
PR bond. I want to go home. I want to go home. I want a PR bond.
40,000.
Please,
No,
please.
no, no.
What we're seeing now is a dramatic shift in strategy. Just moments earlier, the defendant was arguing, challenging the court's decisions, and talking about appeals and lawsuits. But after hearing the bond amount and the possibility of even harsher consequences, the tone changes completely. This highlights a reality many attorneys constantly warn clients about. Emotions can be incredibly expensive in court. Whether someone believes they're right or wronged, a courtroom is usually not the place where anger produces favorable results. Judges are evaluating behavior every second, and once a negative impression forms, reversing it can be extremely difficult. At the same time, the defendant continues insisting that hearing difficulties and misunderstandings played a major role in the conflict. That creates an interesting question for viewers. Do you believe this was primarily a communication issue that spiraled out of control? Or do you think the judge accurately interpreted the defendant's behavior throughout the hearing? Drop your thoughts below because reasonable people may see this very differently.
You
Well, then
disrespect.
I'm suing you then.
Good, sue me. Okay? Come on, bring it on. Can't wait.
I'm never gonna get out, man.
40,000.
Come on, man, don't do me like this.
The court
What?
gives us this possibility.
Yeah, I'll do that, but he's not gonna yell at me and talk.
I didn't mean to yell at you. I can't. I'm deaf. I didn't mean to yell at you.
You use the F
I
bomb.
apologize. Can we start over,
No,
please?
no,
Can we start over,
no,
please?
no, no.
Please, can we start? I can't hear you if I'm yelling. I'm not a
You
tough
use-
guy. I just.
You use the F bomb with me.
No, I didn't.
Oh, you did?
I never cussed you. I would not disrespect you. I can't. I
Listen.
wouldn't disrespect you like that. I apologize.
Listen,
Please, my mom's dying right now. Will you please let me go home?
I'm convinced you can hear a lot better than you think, or at least letting on, because all of a sudden you were able to comprehend. Now, I'm not going to argue with you. I'm telling you, it's June 11th at 9:30. 40,000, 10%. One more word, and I'm setting it for June 25th.
This is a different charge. Why are you doing two different charges? That's not me.
There-
What you read right now is that's not me. June 11th. That's not.
We're gonna get you in front
It's
of
two
the
different
court,
people.
and the court could review your bond at that time. And you can discuss the issues with your attorney at that time.
Oh, you're my attorney. Well, so I don't know how it's
say
going
that.
on
I
here.
said,
I get 5 different things going on right now. That's all.
June 11th is your next court
Thank you,
date,
sir.
is what they're saying.
One thing I've decided, Mr. Williamson, I'm not listening to tough guys. You got it? You want to play tough guy? Get into
I'm not playing
WWF
tough
or
guy.
something. I don't know what to tell you. June 11th.
I'm sorry. I apologize.
No, it's not good enough.
I'm half deaf. I didn't know all the screens were up.
I could set it. I could just find you in contempt of court.
I didn't know that
You
all
have
the
to 30
screens were up.
days. One more word. I'm going to do that. I'm telling you.
I have mental disabilities. Just hold on.
Days.
I have mental disabilities.
Cut
Can you
'em
give me
off.
1 second?
Cut him off, Lisa, please. Wilkins Alexander III. 267-665-269, A and B.
Good morning again, Judge and staff.
This hearing serves as a powerful reminder that bond proceedings are about much more than the original charges. Throughout the case, the court focused heavily on missed appearances, courtroom conduct, compliance with instructions, and the likelihood that the defendant would return for future hearings. The defendant maintained that mail problems, hearing difficulties, and misunderstandings contributed to the situation, while the judge ultimately concluded that the behavior displayed during the hearing justified significantly stricter bond conditions. The most shocking moment, of course, was the dramatic increase in bond. What began as a dispute over missed court dates evolved into a heated exchange that fundamentally changed how the court viewed the defendant's risk level. Whether viewers agree or disagree with the ruling, the hearing demonstrates how quickly courtroom interactions can influence judicial decisions. Cases like this also raise broader questions about communication barriers, personal accountability, and the importance of maintaining composure under pressure. A few minutes of escalating tension ended up having major consequences that could affect the defendant long after this hearing concluded. What do you think? Was the judge's ruling justified based on the defendant's behavior in court? Or did the situation escalate further than it needed to? Share your perspective in the comments below. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.